Hi there, it's Bridget Walker with the Estate Preservation Law Firm again. This is the second video in our series of planning and preparing for your sharing and education conversation. One of the things that we're going to talk about during this conversation is the difference between a will plan and a trust plan. Most people generally fit into those two categories when they decide how they want to transfer assets at death. So first off, we'll start with what is a will plan. There's a lot of misconceptions that a will does not need to go to probate, and that is not the case. We like to say that a will is an invitation to the probate court. You may or may not have to go there depending on how your assets are held. But if you have assets that you own in your individual name without a joint owner and without a beneficiary designation, when you pass away, those assets that are remaining will have to go to probate. Whether it is under a will or if you are unfortunate enough to pass away without a will, the state of South Carolina will write one for you. But today we're going to focus on the will. So that probate process when someone passes away takes about 12 to 18 months to complete due to the strict guidelines that the court provides for the process of going through the probate journey. It is also a public process, so anyone can go down to the probate court and look up a probate court file. Many jurisdictions here in South Carolina have online access to probate files. So anyone can go down there, see what you have for assets, who your beneficiaries are, what your will said, all of those things. So those are the two biggest cons to going with a will plan, is the length of time it takes to complete and ultimately distribute assets to your children or other loved ones, and the publicity of it, being that anyone can see what you have in your estate when you pass away. So that's basically planning with a will. It may require a probate when you pass away, and we'll talk about that more in detail. My plan for today was just to give you a general idea, and maybe you can do some research on your own on our website or on the internet about the difference between a will and a trust. Now, with a trust plan, the biggest advantage of a trust is that it avoids probate, assuming that all of your assets are in the trust when you pass away. Our office gives you instructions, both written and electronic, to ensure that the assets that we can't get into your trust for you, you get in during your lifetime. Because again, if they're not in the trust, you would have to go to probate. And as I said, the biggest benefit of doing a trust is that it does avoid probate when you pass away. A trust is also a private document, so there's no court oversight, and you can protect a lot of the information in the trust from beneficiaries. If you have multiple beneficiaries, you only need to share with that beneficiary what part of the trust pertains to them, and only after you're gone. So it's not a public document like a will. And again, it does give you more flexibility to offer protection for your beneficiaries. We will discuss the will and the trust options at our sharing and education conversation, but that's one of the main questions I always get asked is what's the difference between the two, and what are the pros and cons. So I just wanted to get you to start thinking about that and know that those are two options that we're going to talk about. And make sure to jot down any questions you have after this video or after your research, and we'll be sure to address them at the sharing and education conversation. Again, I look forward to seeing you soon, and if you need anything in the meantime, please don't hesitate to reach out to me. Thank you.